afternoon, everyone. Thanks so much for joining us today. I am Katherine Bennett, Director of the ALEC Process and Procedures Task Force. And today we are really excited to bring you a conversation with Jason Snead, Executive Director of the Honest Elections Project and co-chair of the Process and Procedures Task Force, and Adam Kincaid, Executive Director of the American Redistricting Project. Gentlemen, thanks so much for joining me today. Adam, we're going to start with you. Before we dive too far into Louisiana versus Callais and the decision, can you set it up for us a little bit? Tell us about what this case was, what the questions were, and why it was significant.
Sure. So Louisiana was in the midst of a lot of litigation after the 2021 redistricting. They enacted a map that was very similar to the map they had used in the previous decade. It had one Democrat seat and 5 Republican districts. So that the previous district had been pre-cleared by the Obama Justice Department, and Louisiana simply made the least changes, which means changing as little as possible in order to update the map with the new population numbers. But lo and behold, after they enacted that map, various liberal organizations brought lawsuits against the state of Louisiana, claiming that Louisiana was obligated to create 2 majority Black districts in Louisiana. They said that the population was roughly a third African American, and therefore it should have 2 seats instead of just 1. Louisiana defended its maps, arguing that there's no requirement that there be proportional representation, either by race or by political affiliation or anything else. And so they lost in the lower court. The plaintiffs brought it in front of a single judge in the Middle District of Louisiana, who was very, very liberal, ruled for the plaintiffs expectedly. And Louisiana's case kind of got caught up in the midst of the Alabama litigation that was also at the United States Supreme Court. So after Alabama lost, Louisiana went back down in front of the liberal judge in the Middle District, and she said, you must redraw these maps. The Fifth Circuit actually vacated that order, said, no, you don't. But that fall, which was the fall of 2023, Louisiana elected a Republican governor and a Republican supermajority in the legislature. And they came back for a special session in early 2024. And their first act was to enact an unconstitutional racial gerrymander. Governor Landry said, and the Attorney General, Liz Murrill, said, this liberal judge is going to draw our districts. And so we need to do it ourselves. And we have to draw 2 majority Black seats. So that's what Louisiana did, and they were promptly sued by a group of plaintiffs in the Western District of Louisiana, arguing that what the state had just enacted was an unconstitutional racial gerrymander. They won in front of that 3-judge panel, and that case was also immediately appealed to the United States Supreme Court. The Supreme Court said, hold up. We're going to let you have your elections under your unconstitutional racial gerrymander for 2024, but we'll hear the case. And so they heard the case, and then they did not rule on it. So it was summer of 2025. I'm sitting there at my desk, the last day of session, thinking, the last day of the Supreme Court term, thinking, we're going to get Callais today, where the Supreme Court's going to rule. And then it didn't rule. So they carried it back over for re-argument for the next term. And what the Supreme Court did at that point is they issued a new question presented, which is the actual question that's in front of the court that they have to consider. And the question that they asked at that time was, did the Louisiana's intentional creation of a second majority minority district violate the 14th and 15th Amendments of the United States Constitution? And so that's what keyed up everything for this term. The case was argued in October and was not decided until April 29th, I think, is when we got the opinion. So it was a long lag time, but we got it. And the Supreme Court said, yeah, Louisiana did, in fact, violate the 14th and 15th Amendments. And they gave a lot of more rationales as to why, which I'm sure we can dig into later. But that's the long, winding road of Callais and the Louisiana litigation just in the last 5 years.
Thanks so much, Adam. I know that this is a case that a lot of people have been tracking for a long time. And as you said, it was a very winding road. Jason, I'm going to toss it to you for a minute. When we talk about processes and procedures as a task force here at ALEC and as a wider movement around the country and state legislatures all over the place, we talk about it in terms of making sure that the process serves as guardrails for government and making sure that we follow the law and follow, the democratic and Republican ideals that the country was founded on. I know you work primarily in the election space, but with all of this redistricting discussion, it seems to have a very, very close tie to that same ideal. Can you talk to us a little bit about what you think the importance of is in the processes and procedures of redistricting?
Sure. It's difficult at first blush to kind of take, party politics out of something like redistricting. It's just sort of part and parcel with the entire discussion. But there are first principles here. And of course, one of the most basic is that you have to comply with the Constitution. And the Constitution, as a document, as it's been amended over time, is it very strongly disfavors racial discrimination, right? And when you look at what the Constitution is trying to do, what the Voting Rights Act was originally trying to do, it's not enshrining racial discrimination, it's trying to end it. And unfortunately, what we had seen over the last several decades is the increasing politicization of the Voting Rights Act. So Calais, to me, really represents an opportunity to reset and to restore in the context of redistricting those constitutional first principles. And that's actually extremely relevant, because even though so much of the coverage of this relates back to those party affiliations and which party's going to gain, which party's going to lose, and there's no way to actually explicitly determine that, right? We have elections, we have voters, right? There's so much of that is just unknown at this point. But even though so much of this goes back to that, we always have to remember that in any aspect, in any process of government, whether it is redistricting or election law or anything else, there are those certain first principles, and it is incredibly important that we get those right. And even though there may be folks who will argue that the Calais ruling is unfair because my party is losing seats, whichever that is, no political party or movement has a right to claim representation in a state if the only way they can do it is by drawing maps that are illegal racial gerrymanders. And so this is a good opportunity for us to step back, to reset, to get back to those constitutional first principles. And if you look, Katie, at the statement of principles that we adopted, one of the first things that we adopted in the Process and Procedures Task Force, it has those high-level standards, things like fairness, things like transparency, things like accountability. And all of that speaks to the need for government in all of its operations, including redistricting, to respect the rule of law, to respect the rulings of the Supreme Court, and first and foremost, to honor the Constitution of the United States. So there's a lot of that that's going to get lost in all of the ensuing litigation and all of the ensuing discussions that come in this post-Calais environment. But I think it's always important in any of these contexts in the election space, whether it's redistricting or election law generally, to always be thinking about those first principles and how we execute on those. So this is a really momentous ruling. It's going to have a lot of immediate impacts. And I think one of the best is that we have that restoration of constitutional standards.
Absolutely. Adam, we've talked a little bit about the background now and putting this in context. Let's get into the nuts and bolts of the decision and how the Supreme Court answered that fundamental question that was before it. So can you talk to us, starting at a broad view and then narrowing in, we can look at what this means practically for the states, but starting broad, what does this mean for redistricting law?
Sure. So what Justice Alito's opinion did was it actually just restored the original meaning and context of the Voting Rights Act. Ever since the VRA was enacted, there was kind of a push and pull between not just the left and the right, but various factions within the Democratic Party and factions within the Republican Party on what the VRA did and did not require. And so one of the most famous cases dealing with the Voting Rights Act and how it applies to redistricting is the case called Jingles, which was a long time ago. And the basic the reality of Jingles, though, is that there was not a majority actually for the framework that we've been dealing with all along. There was a concurrence from Justice White, who had signed on to most of the opinion, but there was a very important part of it that he didn't sign on to, and it dealt with concepts of politics and race and how to disentangle the two, right? And so the general point was politics and race are integrally combined together in a lot of places in the United States. And you have to disentangle those things in order to understand whether a district was drawn on the basis of race or off of politics. And there's an important distinction of intent behind those things, right? And so Justice White's concurrence was simply that. It was a concurrence. And for a long time, it wasn't necessarily ignored, but it was downplayed by a lot of folks, especially on the left. What Justice Alito's opinion does is pretty much say Justice White was right all along. So that intent does in fact matter when it comes to redistricting. You can draw a map with 100% political objectives and goals, and that is constitutional. There is nothing in the Constitution that bans you from doing that. You can argue whether or not that's what we should be doing or whether that's the right thing to do, but that's a completely different question, right? And so, or what sort of reforms are possible. But the basic gist is, if you're drawing districts for political reasons, and you're following your criteria, then that is something that is acceptable. And in order for a plaintiff to prove that what you've done has violated the Constitution or violated the Voting Rights Act, they need to prove that they need to adequately disentangle race and politics. And our argument all along is they have not done that. They have not been doing that. And yeah, at its core, what Justice Alito has done is taken the Voting Rights Act and say, the Voting Rights Act still requires that you, certain districts at certain times, the Jingles framework is still there. But for a plaintiff to prove that you violated the Constitution or violated the VRA, you must prove that there was a racial intent behind the drawers and behind the legislators in order to prove that there was something untoward going on.
Gotcha. So is it fair to say that what this decision does is say we can no longer use race to assume a vote or assume that somebody is going to cast a vote in one particular way and use that to draw gerrymandered partisan districts? So we have to take race completely separate from how we are interpreting and drawing the lines.
Look, there was a point a few years ago where people started talking about drawing race blind maps, right? Which means not using any racial data at all. And at the time, my view was, we're not advocating for that. We're not advocating against it. All we're simply saying is, follow the advice of your counsel, right? If your lawyer wants you to draw race blind, draw race blind. If your lawyer wants you to consider race when trying to comply with the VRA, do that within the scope of what your counsel is telling you to do. That would have been where we were several years ago. Fast forwarding to now, I think with Callais and with what we've seen in Alexander, which was a case decided a couple of years ago by the United States Supreme Court, also by Justice Alito, actually. He seems to, he loves redistricting cases, it seems. So, but yeah, I mean, at this point, what we have advised is that, map drawers draw their maps race blind. And don't use race at all. Don't have it at the bottom of your screen. Don't have, any of that sort of stuff. That came up in Texas, right? Where they're like, well, Adam, we know you had racial data in your platform. You must have been looking at them. I wasn't looking at it. I don't use it. I don't want to use it. If you're drawing partisan maps, you draw them for partisan reasons using partisan data, not racial data, right? Politics is a much better predictor of politics than race is. So it doesn't really make sense to use race data anyway. But yes, I think generally speaking, Callais does not mandate race-blind redistricting, but what Callais does do is tell you that to defend against a racial gerrymandering claim, it's best to just not use the race data at all and not have it available at all either. So, we've done that on our end. We're going to continue to advise that moving forward. If states want to do VRA checks or whatever else they want to do on the back end with academics, that's something that the states can definitely do if that's something the lawyers feel like they should be doing. But generally speaking, map drawers should not be using racial data at all when drawing their maps.
Gotcha. Jason, I have another question for you real quick. And as the chair of one of the chairs of the Process and Procedures Task Force, we look a lot at the rules that government is operating under, and not just from a constitutional standpoint, but from a state constitution or a rules within the legislature standpoint. a lot of people look at everything that's gone on with redistricting and think it's one big partisan mess. But underneath that, there are rules that are grounded in ensuring that the voice of the people is heard in the election space. Is this an area that you think we need more clarity in, either through discussions within legislatures or discussions through a wider kind of political movement across the country as we not only get in the middle of this Calais decision and everything that'll go on with that, but as we move towards the 2030 census and the reapportionment and redistricting that'll take place there?
Well, I mean, it's an incredibly important area, and I actually think that that bringing additional clarity to this space is exactly what Calais did. I mean, for a long time, states were basically stuck in this paradigm of, you have to consider a certain amount of race. If you consider too much, you're stuck. If you consider it too little, you're stuck. This gives a lot more clarity to what states are doing when they're redrawing their maps. Whether that is a process that is going on right now, like what we see in Louisiana, or whether that's a process that takes place after this election cycle, like what we might see in Georgia, or whether that's something that takes place after the 2030 census or any census that comes thereafter. I think that one of the overarching themes here really should be that process does matter, right? And that is actually why we have the Process and Procedures Task Force, is because legitimacy is not found in the end result, but in the way that you get there. That's true in elections, and I think that's true here. And there's other examples of that in the redistricting space going on right now in Virginia, where there's active litigation over an attempt to redraw, where in order to get that done, the legislature rushed through a referendum to get it on the ballot last month, and ran roughshod, I would argue, over numerous provisions of state law and the state constitution in order to do that. That is now up for consideration in the state Supreme Court, and they might get struck down, and we might get another round similar to what we saw after Calais last week of accusations of unfairness, and it's all reduced back to party representation. But really, I think the overarching theme here is that process matters, and adherence to your constitution, whether that's your state constitution or the federal constitution, matters. And deliberate decisions, whether that is misusing the Voting Rights Act and essentially dressing up, as Adam pointed out, dressing up political partisan gerrymandering claims as racial claims, or whether that is ignoring the referendum rules and rushing something on the ballot, that those decisions, those bad decisions, don't create a right then for you to expect that, well, we can just forget about that because it's all about the end result. That's not the way the process works. And when we get into that kind of mentality, it actually discredits the entire system in the eyes of voters. So that's what I certainly hope will be one of the big takeaways. But then, just to kind of circle back to the original question, do we need more clarity? I think we've just got a lot more clarity in this space. And I would certainly like to see less litigation going forward in this, because as Adam said, right now, a lot of the chaos that we're seeing is just because the left is unwilling to give up these unconstitutional gerrymandered maps. And they would actually rather Louisiana conduct an election that it doesn't need to conduct under an unconstitutional map that infringes on the rights of the voters of that state. So we'll see what we get going forward. But I think that Calais was a big win just from that clarity perspective, as far as what states have to do when it comes to racial gerrymandering. And the short answer is just don't do it.
Thank you so much, Jason. Adam, are there any final thoughts you would like to share with us?
Yeah, I mean, look, we're going to have a whole bunch of litigation, as much as we like to avoid it, over the next few years, as the left tries to, again, stretch and pull the VRA into a direction it's not meant to go. And I think we all, states, as they draw new maps, either now or after 2031, need to be cognizant of what Justice Alito has written now in Alexander and in Calais. And I think that, there's always a temptation among lawyers on both sides of the aisle to push or pull the law in the direction they want it to go, right? And I think that with these cases, we have a framework that creates a very clear safe harbor for map drawers, whether on the left or the right. And in the long run, I think this will help cut down on litigation. But in the short term, I think it's very important to be smart about how we go about these things, be intentional about how we design our maps, the reasons we're drawing them, and be very clear about that, and work within this framework that the court has clarified, which was desperately needed over the course of the last 20, 30 years. It's been just a muddle of you can do this, but only in these times. So it's just, this is a much better space for map drawers, like I said, on both sides of the aisle, moving forward.
Thank you so much, Jason. Do you have any final thoughts you'd like to share?
I mean, I think that we just got a master class in redistricting law from Adam. Graduate level presentations there. It's mind blowing, and it's always great to be able to come on something with Adam. No, I mean, I think that we've got a lot of work ahead of us, and Katie, I know on the Process and Procedures Task Force, we're going to continue to look at all aspects of government procedures from that constitutional first principles perspective, which I think this was a big win for. And I know there's going to be many more opportunities to be talking about the role of the Constitution in all of those. And I'm looking forward to the discussions in the task force on an ongoing basis.
Well, thank you so much for being with us today. I know that the people who watch our content and follow us on social media and come to the ALEC conferences as members really appreciate having such high-level experts here to help explain really what is going on, which is a large part of the purpose of ALEC, right? We are a convening space for the public sector and the private sector and everyone to come together. So thank you, Adam, for walking us through the kind of nitty-gritty about what this case is and what it was and why it was important. And Jason, for helping us keep an eye on the big picture of the importance of process in the process. So thank you all, and I hope you will join us again soon.